Hello, this is Court Watch with Alex Sawyer, and I'm excited to bring you the 5th episode of my podcast where we will be talking about some of the Supreme Court's major cases coming up in February. But first, we'll recap this month's arguments where the court heard a handful of cases, including one dealing with attorney-client privilege, and how courts should handle communications between lawyers and clients when they contain some, but not all, legal advice. For example, if a communication, like an email, included guidance on non-legal matters, should that, in total, be protected or not? And the justices also heard a dispute from a Turkish bank that is challenging criminal prosecution in the United States for allegedly skirting Iranian sanctions. The bank argues that federal law doesn't allow foreign states to be prosecuted criminally in the United States court system. More newsworthy, though, to most of my readers are cases coming up next month, including a review of liability for social media companies, and whether President Biden's plan to forgive millions of student loan borrowers' debt is legal. We'll be chatting during this episode with Elliot Mintzberg, who is Senior Fellow and Counsel at People for the American Way. He also served during the Obama administration as General Deputy Assistant Secretary for Congressional and Intergovernmental Relations at the Department of Housing and Urban Development. He'll recap some of the court's major disputes with us and also weigh in on how he thinks Justice Ketanji Brown Jackson is doing during her first term since his organization supported her nomination to the High Court. Hey, Elliot, thanks so much for joining us. I want to first talk about some of the cases that were just addressed during this January sitting. And I wanted to ask you, particularly with you watching the court, are there any of these over the past 2 weeks that you have a focus on? I did cover the NRA grand jury arguments about the attorney-client privilege issue. I didn't know if you've been paying attention to that one or what your thoughts were on that as well.
Well, I think the January case we're watching most closely is the Glacier Northwest case that has to do with a challenge to unions' basic right to strike and whether they can be sued by a company for alleged damage that a strike causes. It should be the NLRB that determines whether there's any liability there. The company is trying to contest that, and that would be extremely harmful to unions. But frankly, we're paying more attention to the 4 big cases that were argued before January concerning affirmative action, concerning redistricting that has a harmful effect on racial minorities, concerning democracy and voting, whether a state can essentially ignore its own constitution in making decisions through its legislature about what to do with respect to presidential elections, and the so-called 303 case about whether free speech can be used as a sword to harm laws that protect discrimination against LGBTQ people and others. Those 4 that have been pending for a while are still, I think, occupying most of our attention at this point until we get to those cases in February that we'll be talking about in a minute.
Exactly. Like, no disrespect to the January sitting. Like, there was some interesting cases, but like you mentioned, there's a lot of interesting ones that are already argued or are coming up next month. So, like, while I have you here, I guess let's start with affirmative action. What was your take from those arguments? Do you think it's going to be chipped away?
Absolutely. Unfortunately, I think there is a very clear majority to at least chip it away, possibly eliminate affirmative action with respect to college admissions. We don't know. The argument, as always, was interesting, but the last decisions to uphold affirmative action were 5-4, and that was before some of the key Trump justices joined the court. So we'll see, but I'm not optimistic.
Mm-hmm. And then you mentioned the election law-related dispute, Moore v. Harper. I think it was, if I remember, this was when I covered the arguments, I left thinking, I was kind of surprised that there was, I think, skepticism from some of the conservative justices even about some of the arguments that the lawyer for the North Carolina Republican lawmakers were making. It seems like, I think Justice Roberts was, I think I'm trying to remember, there was like a part in the arguments where he kind of like brought up well, if we don't buy this argument from you, there's a part of your brief that has a more narrow argument. Like he's trying to, I guess, strike a balance of some sort. What was your take? Do you think that they're going to try to come up with some sort of like compromise? Or do you think they're going to give like state legislatures full authority over election laws and not, I guess, having courts check them?
I think the court, including the right-wing members of the court, are going to be split on that issue. Roberts tends to try to find a middle ground in those kinds of cases. But as we saw in the Dobbs case, the far right on the court doesn't need Roberts to get a 5-4 majority. So I think we just don't know how far they will go. But it's potentially very dangerous if they fully accept the North Carolina argument, because it would literally mean that state legislatures can ignore their own constitutions in setting their own rules, whatever they would be, with respect to presidential and related elections, which would be very dangerous to democracy.
Mm-hmm. Yeah, I think there's certain arguments I leave the courtroom thinking I have some sort of idea the way the justices will go. This one I wasn't so confident. I don't know what kind of balance they're going to strike, but I don't see, at least when I left, I didn't see there necessarily being enough of that conservative wing to side completely with the North Carolina lawmakers.
I hope that's right, but it's just hard to predict.
Now, go ahead. I was going to go ahead on this one.
No, that's my only point. It's just very hard to predict.
Yeah. So,
and they went very far last year, as we know, in Roe. And sometimes the question is, will the court do that 2 terms in a row, or will they pull back a little bit? It's hard to say. That case, the affirmative action case, will tell us a lot about that.
And then with the 303 Creative, the issue with the web designer who says that based on her religious beliefs, she can't create custom websites for same-sex marriages. It's almost like a repeat of the Masterpiece Cake Shop case. I believe that was in 2017, 2018, where the Christian baker said he couldn't make a wedding cake for a same-sex wedding. Now, when we talk about striking a balance, I felt like that was kind of where we found Kennedy's opinion with Masterpiece. Like he said, hey, this baker didn't get a fair hearing, but this court didn't really come down on how to handle these disputes, right? These First Amendment versus LGBTQ rights. So now it's, to me, when I left that argument, I did think that there was more of a focus from the court, at least a majority, to try to come up with some sort of rule. Did you think the same listening to arguments?
I do think that there will be a strong effort. Now, unfortunately, that Kennedy is gone and has been replaced by a Trump justice, to come to some conclusion on this. The question again will be, how far will they go? Will they argue that this religion or free speech argument completely overrides the Colorado law? And if so, does that also mean that other key civil rights laws are in jeopardy? What about someone who wants to do this kind of work and says they don't want to serve interracial couples who want to get married? Why isn't that in jeopardy for the same reason? So I do think the right-wing majority is more likely to reach a substantive result, but how far that result will go, again, is the key question.
It sounded to me like, I remember Justice Kavanaugh, for example, his questioning was, how do you characterize like a web designer, right? Like, is it a publisher, or is it like a service provider? And I don't know if that's a glimpse into maybe where they try to draw the line. I'm not sure.
I think that's quite possible. And a lot of the really interesting hypotheticals that they came up with sort of suggested attempts to figure out how to draw that line. Mm-hmm. But again, we won't know until we see what they do.
On that same topic, religious liberty, the court, you and I emailed earlier this week about it. There was a grant where they're going to hear a case from a correct me if I'm getting any of this wrong, but I believe it's a mail delivery man who lives in Pennsylvania.
Yep.
He says
Yep.
he can't work on Sunday Sabbath, that's a day of rest and faith and worship for him. And so it seems like since I think it was 2012 that whichever office he worked in, they were able to substitute out his Sunday shifts. And it became more of an issue when like the post office is contracted with Amazon. There's all these package deliveries like on Sundays. And now there's just the office is too small to accommodate always finding a substitute on Sundays for him. So the Supreme Court his lawyers say he had to resign essentially because he was facing, potential, I guess, penalties, issues with his job. And they've sued. And the court agreed to hear this challenge. So I guess, what do you make that the court has agreed to hear this dispute? And do you think that this is one that could be heard this term? I mean, we don't have calendars for the March or April arguments yet. Do you think they'll hear it this term?
I think they could. And my hope is that this may be a case where there can be some consensus on religious liberty. What this case does is looks back at a case decided in the 70s called TWA versus Hardison, which said that under the federal statute that says that employers should try to accommodate an employee's religion, anything more than a de minimis cost, that was the phrase that the court used, is more than the employer can be asked to bear. Well, one of the strongest dissenters in that case was Justice Thurgood Marshall, who said this doesn't offer any protection at all. And both Republicans and Democrats have been very critical of the decision since then. There even have been efforts to change it legislatively. And my hope is that what the court will do, both liberals and conservatives will look at this and say, this isn't fair. It's not really what the statute says. Look at comparable laws like those that protect disabled people, and let's interpret it a different way. Again, the question will be how significant a burden is placed on employers, and this is a critical question, will this be used to impose burdens on other employees, which I very much hope not. But my hope is that this is one where the interest in religious liberty that I think both moderate and right-wing justices have can find some common ground here and come up with a standard that better protects religious liberty.
Right. Yeah, that'll be one that's interesting to watch. Given everything going on, like there's been the post office has even just been in the news since I guess what was the election in 2020. So I think that there's also like some sort of eyes on how to treat the U.S. Post Office and because that's the employer at issue here, right? So
sure.
That could get some attention as well from various outlets. So I guess let's go ahead and dive into February, because I do think that that's going to be one of the most interesting sittings, because I there's 3 cases at least that I think are going to be some of the biggest ones this term to complement each other. So basically, I think it's Gonzalez versus Google, and then correct me if I'm mispronouncing this, but Twitter versus, is it Tamnay? I don't know if I'm getting that wrong.
I think that's right. I may not have it right either. Right. Those are the 2 cases relating to the internet and social media.
Right.
And they are very, very important. For a little bit of background, one of the reasons internet and social media have grown so well is because of the protection that they have, both from the First Amendment to, as private actors decide on their own what to take down and what to put up on their platforms, but also, excuse me a second, also Section 230 of the Communications Decency Act that says that they can't be held liable for something that they simply allow to be on their platform. The person who did the speech can be liable, but not the platform itself.
Yeah.
And these cases question 230 in a fairly direct way. The Google case claims that this is a case involving an awful terrorist episode in which the victims are essentially saying that what what was done was that through an algorithm, the website essentially directed people to one of these terrorist videos that then allegedly helped cause the awful tragedy.
Right. I think they're saying like it helped ISIS recruit members or something like that.
Right.
I think is part of the argument.
I think that's right. And the question is, can simply having an algorithm that automatically directs people to a site without any actual specific conscious recommendation by the website or social media itself, is that enough to eliminate Section 230 immunity? The lower court said no. The plaintiffs say yes. The other case has to do with whether simply by leaving a terrorist video on the site, they can be charged with aiding and abetting a later terrorist incident when they could have chosen to remove it. Both of those, again, the lower court said no. Section 230 protects. The very fact that the court took those when there was no conflict between circuits on this issue suggests there are at least some members of the court that are very interested in looking again and possibly limiting Section 230 immunity. We don't know. Now, I should mention.
Okay, go ahead. I was going to say, where do you fall?
You go ahead.
Well, okay, so everybody following this sort of social media issue, they hear from a lot of Republican lawmakers that are critical of like companies like Twitter. Then Elon Musk, came in, took control. There's been all this like news about social media and its influence and that sort of thing. Now, taking the politics like out of it, the Section 230 of the Communications Decency Act, correct me if I'm wrong, but I think it dates back to the 90s. Yep. And looking at just from a legal lens and a practical lens, no politics in it, I'm curious, the internet has changed so much since the 90s, right? Like Facebook didn't exist. Twitter, right? I guess, where are you on this? What do you think?
I think it's a tough issue. I think it's a very tough issue.
Extremely tough, because how do you the law can never keep up with technology. Right,
and I'm glad in a lot of ways that the court is looking at the issue, but again, where they'll come out is a little unclear, a lot unclear. And Facebook does arguably make a difference. Social media hardly existed back in the 90s when this started, but the principles arguably aren't different. And do you want to hold these folks liable for stuff that they just allow on their platforms? Now, the opposite question is about to come to the court, because there is a conflict in the circuits below on a different issue. Several states passed laws that limit the ability of platforms to take stuff down from the internet. And one court, I think with the 11th Circuit, said, no, you can't interfere with those decisions. The Fifth Circuit went the other way. And that case comes to conference on the court this Friday. Now, they may not decide whether to take that case. They may decide to hold it off a little until they look at the issues in the other two cases. But that one's knocking on the door, and that one does get to some of these political questions. In fact, at least one of these cases had to do with lawmakers in one state being upset about Trump material being taken down from a website. So both parts of internet and social media freedom are potentially under review at the court. Section 230 and the First Amendment right to take things down when they want to from the internet, and those are crucial questions that have enormous impact. And as you say, given all the changes that have occurred, How the court will go on all those is anybody's guess.
And then I don't know if you've had a chance. So like for our non-lawyer listeners, like there's a friend of the court briefs, like different interest groups file. They're called amici, right? And so like, I don't know, have you had a chance to look at any of these? Like it's different groups or people who have research or expertise trying to make arguments to the justices. I'm curious if they're going to break down ideologically.
It's a little harder to tell here. I think that some of the right-wing justices in the past, like Justice Thomas, have expressed some concern about Section 230 and wanting to do something about it. But again, how far he wants to go and where other justices will be is very unclear.
Yeah, and I did look. It looks like the federal government, the Solicitor General, did file a brief in each case, and usually when they do, they support either the petitioner or the respondent. And it looks like now, with the Twitter case, Twitter being the one appealing the lower court's ruling, I think they said that they wanted to support. They didn't say Twitter, but it said basically reversal. And then on the other one, it said that they wanted to vacate the judgment. And essentially, it seems, at least from my quick glance, that they're trying to encourage some sort of balance, like you were mentioning. I think there was a line in one of them. I don't know if I have the brief handy, but basically, can these companies be held liable for what others post on there? Maybe not. But then could they be responsible or held liable for breaking their own rules that they set out for themselves? Does that make sense? Like if they fail to police, I guess, their own rules.
Oh, yeah. And the question also will become how deliberate does it have to be for the company to be held liable? That's why I think the Google case is so interesting, because the argument is that it was just an automatic algorithm that essentially directed people towards a website. It didn't involve any real conscious, deliberate decision to do that. Is that the same as if they had made a deliberate decision to direct users to the particular website? That's an important question, and we'll see the answer.
Yeah. Okay, so also in February, that's not all that they have. They have President Biden's student loan forgiveness plan up for debate. And it looks like I'm a bit confused on this one because so there was a case brought by a group of states that have challenged what the president is doing by forgiving certain student loan borrowers. Yep. And then there was another case brought by borrowers. And I thought both courts had ruled against the administration and left like an injunction in place, not allowing them to go ahead and roll this plan out. But the court went ahead and took it up. And usually I thought, they usually take cases that have conflicting lower court rulings. Tell me if I'm wrong. Did I get one of those rulings, those lower court rulings wrong? And if not, do you think that signals that they might side with the president here, or what? Like, do you have any reading of this?
I think it's hard. I think it's hard to say. I mean, the Supreme Court did, in this case, basically decide to sort of suspend the operation of the program, but it was done in a way that shouldn't, in the short term, cause injury. And there really are two issues presented here. First, who has standing to challenge this student loan program? And that's important not only for the student loan program, but for lots of other things that states in particular, particularly right-wing red states, would like to challenge what the Biden administration is doing. And standing is a subject on which traditionally conservatives on the court have been conservative, but they have been a little bit more interested in allowing challenges to more progressive policies of Biden and others. So that's going to be an important issue. But then the second issue that literally affects millions of students is whether, in fact, the Education Department has the authority to do what the president wants them to do. And if they might not get to that question, depending on what they decide on standing, but if they do, it's going to have enormous significance to millions of people across the country.
Mm-hmm. I know one of the arguments, I think, was that it should, I can't remember which brief made the argument, but about Congress could do this, but the president couldn't. I don't know if they'll buy into that, but I'm curious, like, given the the ideological breakdown of the court, if that would be one of the arguments that you think that they would be open to.
I think definitely will. There's the so-called major question doctrine that some right-wing members of the court have tried to push, and have successfully in a few cases, where they argue that an administrative agency can't decide what they call a major question, that it has to be from Congress. Now, the more traditional view of that is, well, if Congress delegates that question to the administrative agency, that should be perfectly okay. It's an effort more broadly to cut back the power of administrative agencies, and to a certain extent, the president. And that could very well be an issue that will come up.
Mm-hmm. While I have you for a few more minutes, I wanted to ask you, I know your organization supported Justice Jackson's nomination and confirmation to the Supreme Court. She has been interesting to watch because I covered the 3 Trump appointees, and when they first got on the court, I don't want to say they were timid. I don't know if that's the fair word, but they weren't as vocal. Like, she's been very vocal. And I thought I'd ask you, how do you think she's doing? What's your take so far? It's kind of cool to see someone new, I guess, be as, I don't know if aggressive is the right word, but vocal, not afraid to pipe up and ask questions.
She has been, I agree with you 100%, and I think she's been terrific. She has been vocal. She's been incisive. She's used a lot of the techniques that some of the right-wing members of the court use, looking at, for example, in the affirmative action case, looking at the history of the 14th Amendment. She's the way the arguments work now. It's hard for any justice to be totally silent because they each are called upon in turn. But she, because she's towards the end, comes right after Barrett and Kavanaugh, and she very often picks up on their questions in a way that, again, we don't know what's happening in conference, but suggests that she wants to try to influence what they may be saying or thinking. And sometimes it could well be the votes of Barrett and Kavanaugh that determine whether on the right you'll have a more middle ground position that Roberts might like, or a more extreme position that Alito and Thomas might like. So I think she's been absolutely terrific. We obviously have to see what happens as she starts writing opinions, and others do. We haven't seen a single opinion from the court yet, which is somewhat unusual. But I think she has been absolutely terrific.
So because we don't have really opinions or see that breakdown yet, this might be an unfair question. So if you want to avoid this, the next time you're on, you can answer it. But Kagan seems to be more of the moderate from the liberal wing. Do you think you know yet where Justice Jackson will fall in terms of to Justice Sotomayor's right or left, or is it too early to tell?
No, it's way too early to tell. You have to actually see how she votes in opinions. In some of the, not full opinions, but some of the votes of the court, she's lined up with Sotomayor on death penalty cases and a few others. But it's way too early to tell, and I'm happy to talk about that later after we see some votes and opinions by her in argued cases.
Yeah, no, I think that's probably one of those stories that's in the July story, August, looking back at how things went during her first year and where she seems to vote on various top issues. Let me ask you one last question while I have you. So I was out during holidays, but there was the Chief Justice issued his annual report, I guess that he does. And so I didn't write a story or anything on it, but I did take a look and I thought it was kind of interesting. So first, it's usually statistics, right? And that's what he included, but he did have a couple pages of the late Judge Davies, I believe it is, who had in Arkansas with the ruling in Brown v. Board of Education and the order to make sure that, Black students were able to go to a white school, that he faced a lot of threats was mentioned. And then he also talked about how that his bench will be on display at the Supreme Court, which is pretty cool for people to come see later this year. And then he thanked Congress for passing laws. I think it was back in 2021, if I recall, for helping secure federal judges. When I saw that, I asked a couple court watchers, hey, has he ever done that before? And the reason, of course, is I'm thinking what happened with Justice Kavanaugh following the Dobbs leak, was that on his mind? And many of them said, yeah, it had to have been. But I'm curious, to talk to you, I guess, given that it's January, there's usually the Women's March, and then, of course, the anniversary of Roe v. Wade, everything going on, the pro-life, I know, March for Life comes to DC. Do you think that this is judicial security, for example, is more, and not just talking about the Supreme Court, I mean, just up and down the courts. Do you think it's more of an issue now because of the rulings or politics or both? Are they just becoming too intertwined?
Well, I think judicial security is an important issue, and it was important for Chief Justice Roberts to talk about it, partly for the politically related reasons that you raised, and frankly, sometimes just because people disappointed in what individual judges have done can unfortunately all too easily pick up a gun or other weapon and be a threat. And with that, I think the Chief Justice was on the mark. What I think was disappointing about his report was he said nothing about the ethics and transparency issues that have really hit the court in recent months, and the growing concern that the Supreme Court justices are the only judges in the country that aren't subject to the ethics rules that govern all other federal judges. I know the Senate Judiciary Committee. Recusals, explaining recusals, frankly, even the growing shadow docket is a concern about transparency as well. And I know the Senate Judiciary Committee is going to have hearings on this subject, which I think is an important thing to do. I frankly hope that the justices will feel a little more pressure to come up with some kind of standards in this area, but certainly Chief Justice Roberts didn't mention it.
Yeah, no, I think, and you talk about the Senate Judiciary Committee and even the House, I think both should, of course, all this becomes partisan, but looking at it, there's arguments, I think, from moderate lawmakers or bipartisan, there should be bipartisan consensus on both of those, judicial security matters as well as ethics and transparency.
I hope that's right. Unfortunately, I think that many politicians on the right have perceived this as an attack on the Trump justices and on Justice Thomas, and I don't think that's true. I think that those who are concerned about it, including us at People For, think this is an issue that should be bipartisan. So far, it hasn't been. We'll see.
Well, I thank you so much. You've been very generous with your time. I think I told you it would be a 20-minute chat, and we've been on the phone for 35 minutes. So I totally, really, appreciate this morning chat we've had. And I want to have you back for sure once we have some of these major rulings so you can break those down. And also, like we talked about, take a look at how Justice Jackson did during her first term.
I'd be very pleased to do that, Alex. It's been fun.
Thanks for tuning in to the 5th episode of Court Watch. If you have not subscribed yet, please do so, and also feel free to email me interesting questions or topics you want explored about the legal reporting world. I'll do my best to answer them during each episode. Thanks for listening, and I look forward to hearing from you all soon. Listen to my podcast, Court Watch, at WashingtonTimes.com or wherever you get your favorite podcasts.